Okay, how is my sound, folks? Okay. Okay, good. Like I say, the last class is going to be an early time. Um, I will have to do 3 classes in one night because of just the short week that we're in. As usual, I think everybody here in person knows that we finish on the 19th. If you're listening by recording, I want you to hyper focus and put it on your calendar right now that we're finishing on the 19th. And I realize this is a 2000 level course, so most of you are in like your second year of paralegal studies, or you've been in it at least a few quarters, so you know the drill, but it's easy to still forget that you have to finish much earlier the last week than you do the other weeks. So finish strong. You don't have that many days. You've only got 8 days to finish the course. Do the best you can. I think it's interesting. Damages to property. Based on some of my business investment experience and just simply, I like math. This is easier for me. You're compiling estimates. And then, of course, the other ones would be the specials, adding up bills. Those make the most sense to me. You know what is kind of hard for me is, and I think for a lot of people, is physical harm, general damages. What's a general damage? Hard to define, but put yourself in the place of a jury and you're just asked to compensate somebody $1 million for general damages. Not based on specific bills the person has. More based on bills they could have in the future. Okay? Bills, general trouble, just general damages. That is a hard concept. I like specifics. Specifics, like I say, are easier. Property damage and things like that, easier to calculate. Are we really calculating general damages, or are we estimating? We're really estimating. Damage to property fair market value. Any speculations on what that might be? If you've ever been in the real estate business, you have a grasp of fair market value. What might it be? Yes, that's right, Beth Berger. What would it cost to replace an item in the current market? So for personal goods, it's similar to real estate, yes. Yeah. Yeah. Katie, value of similar properties. So if we ask for 200,000 due to the tortfeasor, the bad guy, if we ask 200,000, the word do shouldn't be in there. Oh yeah, do it. Yes, that should be in there. Excuse me. If we ask for 200,000 due to the tortfeasor destroying a home, if it is not fair if the house would have only sold for 100,000. Well, the house has enormous sentimental value because we could say, well, it's the home. It's a home. It's a family home. But if there were no personal injuries, in other words, injuries to a human being, it's pretty cold and hard calculation. It isn't going to be a sentimental calculation, okay, for a house. General damages are calculating damage to physical harm. Memory cue, general overall losses, GOL. Special is more bills. Think of overalls and siblings. So that's just my memory cue. You don't have to use this, only if it helps you learn it. So general overall losses, GOL. Special is bills. And I realize that's not wonderful grammar, but that's why it's a memory tool. It should almost grate on you a little bit that it's bad grammar. It should say specials are bills, but then it doesn't say SIB, SIB. So general damages, why do general damages seem like the opposite of general damages? They don't seem general to me, but they're not bills. What are they? What does the text say they are? Textbook is faster than looking up lots and lots of cases, case law, because a lot of the case law is so old that you would have to look up a bunch of cases to get the same information. And most of these definitions are true nationwide. The general definitions of general damages are not reinvented in each state. So I would say take a look at them and share. I'm going to share content. Fear of injury, loss of consortium, disfigurement. These are kind of odd because they're using $20 words for things. But it pays to write these down and try to learn them. Loss of consortium damages. The loss of a spouse does have monetary value, and there's some creativity in trying to calculate it out. But apparently, according to the tax nationwide, there's a lot of creativity in this. This is not based on hard and fast rules, but it does pay to read through this in the text. Here's page 87 that explains some of the general damages, okay? And here's page 85. So there are ways to estimate damages so that we can settle them. In most civil cases in my state, they are settled either by just normal bargaining or by mediation. Last year, there were almost no civil cases actually tried to a jury in my state, which kind of astonished me. But that's why I keep going to these meetings. I keep going to lawyers' meetings because I hear things there that you would not maybe pay attention to otherwise, because they're not the result of a legal change or something that you're going to see in a case law. But that was something that you see when you talk to judges and appeals court judges who track these for the court system. So in my state, at least, they're able to resolve these, but of course, the other side could pick your side's pocket if people don't comprehend these things well. Insurance companies have special software programs to try to determine how things are settling, but of course, a lot of these settlements do not become news, so it does pay to have the lawyer, if you can't go, have the lawyer go to the next continuing legal education and hear from other lawyers that have already handled this type of case, and then to get the estimates. You compare case to case to case to case. Permanent injuries, of course, have much higher damages than temporary injuries, typically. I suppose a temporary injury that's extremely painful could maybe get the same, but and then we'll look up special damages. Some of these even seem kind of abstract because you've got loss of earning capacity, but it can be calculated. Your side may have to hire an economist or at least an accountant to calculate loss of earning capacity, but it is based on actual pay stubs that you can get, or in knowing the typical career path and things like that. There are ways to get the statistics for these things, but a lot of it that I have done in the past is just simply to add these things up mathematically. You get the past pay stubs, the past tax returns, and then based on what the doctor says, you find out that the person cannot work probably for at least 2 years, and you can calculate a lot of this out. Special damages. And of course, the expenses are bills. So special damages, I would say, not that super easy because somebody has to do the detail work, but they are not difficult conceptually. They're not difficult to comprehend. General damages have to be stated in such a way that the jury comprehends them and is willing to award appropriate damages. You prepare for a jury even though there may never be a jury. Like in my state, if they're prepared for a jury, the other side may settle, okay? If you're not prepared for a jury, why should the other party settle? They know that you don't have the goods, okay? And this is just a list of documents: summons, complaint, answer. How many of you have had civil litigation class already? Okay, you haven't all, but anyway, these are the items that are brought up. Summons, complaint, just to start a case for the plaintiff. These are the starter documents for the plaintiff side. And this one would be for the defense side. And in a typical case, the insurance company would pay for the lawyer for the defense case. So the answer shows why the defense side doesn't owe for damages or should be minimized, and so on. Certificate of representation and parties, that is used in many states, and that is just kind of a formal document. Let's say Corey and I were the lawyers. I would say, well, I'm the lawyer for the plaintiff, and I would give my full name and so on, and my attorney number. And if Corey was the attorney for the other side, then I would list that, and then I would list the names of the parties. Notice of motion and motion. There may be motions. I may be dissatisfied with what Corey has sent me in discovery, which is where legally I can ask Corey's side for information. And if the information is not complete, I could do a notice of motion and motion and ask the judge to order that they turn it over. Okay? Informational statement is just typically something that you would do before a conference with the judge where you give the details that are required by the state form on what basically is happening with the case. And then a court order is what it sounds like. It's an order of the judge. And there would be different types of court orders, of course. Discovery, this is review for some of you. These are open-ended questions. Production of documents and statements. These would be asking for items and not asking questions. I don't know what people, what irks me about the way lawyers do stuff is they don't ask the correct questions and they don't ask for the correct documents, and that's bad. So don't ask if there are documents. Just ask for the documents. Do you understand what I'm saying? For these, we're not asking questions. If I ask for the last 5 tax returns, I wouldn't say, do you have any tax returns? I'd say, supply Does that make sense to folks? And it says request for production, we need to be bold in how we ask. We don't ask if they have any. Oh, you don't have any tax returns, do you? You don't have any pay stubs, do you? No, we don't ask that. We say supply pay stubs for the last year, supply tax returns for the following years. We just ask them for them. Okay. We can even demand. Same thing with interrogatories. Good question, Corey. I would, if you do an extremely broad question, supply all documents related to this case. Think of it from the judge's point of view. If you're that broad, I think the judge would say, well, I don't know whether to penalize them or not for not supplying this because you didn't really ask for it. You want to ask for some specific documents too. Well, it's just sometimes if you can make it a little less broad, it helps. I'm just, like I say, putting myself in the place of a judge. And you ask for all documents related to the entire case. If it wasn't crystal clear that those are documents that are going to be used in court, it would be really hard for a judge to do that. So I think you could get by with that in a collections case though, but even there you'd want to be a little bit more specific. But I don't think in a personal injury case, I think you could get by saying supply all in other healthcare bills. I think you could get by with that. Usually they're more particular than that. But they know what you want. I think the judge, even though you didn't ask them for super specific stuff from specific providers, you might get by with this one. I think that if there was a chiropractor bill, rather than typically medical, I think that the judge might think the other side should have provided it. But if you think there was a chiropractor involved and a naturopath or something, I would ask for that too. I would probably do the chiropractor one too, okay? Yeah, and Corey's is a good question because how specific do you have to be? Some states really do want voluntary discovery at the beginning of each case. So in some ways, Corey's method kind of works because it's already built into some states' discovery rules, okay? Let's take a look at it. We'll try to be as specific as we can with this. The person that hit Mary's car has gone to an attorney to help him through this case. This person's attorney sent Jane Smart a request for production of documents. Use this sample document and prepare a request for production of documents. Okay. Okay, so and this one says Jane Doe versus Samuel Smith, so it has not got the correct names on it yet. Mary Bowman, okay. Yeah, it's a little ambiguous, isn't it? But yeah, that's the way I would read it too. Yeah, I would do that. But if you do the one for if you do the opposite side, or if you've already done that, that's okay too. Either side is okay. I guess a defense side you would ask for damages and causation questions, right? But then the plaintiff side, when in doubt, nail down the plaintiff side causation, ownership of car reports. How about insurance coverage? If you're on the plaintiff side, it's really annoying to find out that the person has absolutely minimal insurance, but either side, of course, either side you can ask for basically any documents that could possibly lead to evidence. Let me see. You could ask the oh, there isn't a number here. Okay. Yeah, you don't need to do that many. I think it's 10. Let me show you. Yeah. Well, most of this is for the memorandum, not for the other. Okay, request of production of documents is worth up to 10 points. Okay. So look at the rubric, but if you ask for 10 documents, I'm more than satisfied. So basically, a lot of this is the possible damages that you can relate to the facts. So what if you ask for damages? No, you don't have to do that. Once you gain the points, you don't lose them, Samantha. And I was going to bring that up with the memorandum too. Yeah. School in some ways is harder than real life, but in some ways it's easier. In a law office, you have to you have to be concise frequently and in a rush. But we don't do that here. No. In a law office, you frequently don't have time for it, but expand as needed, earn points, don't lose them. Yeah, conciseness, other teachers will help you with concise, okay? Cut it all down to size. For my class, go ahead and expand. Let's say that you you argue for damages that are not correct. And a bunch that do possibly apply. To me, that's good. That's good staff work from my point of view. If the lawyer does not like them all, the lawyer can just X out the ones that don't apply, and then has some concrete work from you on which ones do apply. So just get it down in writing. And of course, the other thing that's nice for you to do, which you can't always do, is to comment on your own uncertainties is fine. Embrace uncertainty. Don't fear them. So let's say that you're pretty confident about a bunch of damages, and then there are several items of damages that you think, oh, bunk, I can't figure out whether these apply or not. So you have damages list. So you start from basics with a high confidence level. Cite the text for each one or other source. You get more points for the text, frankly, because then I know you're reading through lots of stuff. You're not cherry picking. More reading, more thinking. But then as you progress, find some damages that you have to question. And just say, not sure. So that's something that nobody's going to tell you to do in the law office. Master the obvious first. Everybody does. But a lot of times people are afraid to cite and work on the items that might be true, but they don't have a confidence level. Okay, and true, you won't necessarily think about those, but I want you to be able to do that, okay? And yes, you should identify them, you know, use where you're getting to these items. You can have your own code that's used with the lawyers. You can put them in yellow or red or something. Less confident level. So I would start any legal project by master the obvious on top, what you've already known for sure. But keep going. Correct. And this damage I'm not sure of, and here's why I'm stymied. This is why I'm stuck on this one. Not knowing is acceptable. Bluffing is probably not acceptable. Especially it's between you and the lawyer. Don't bluff. Just be open. Paralegal should not be so hyper-competitive that you're afraid to admit that you are not sure, you are uncertain. One thing lawyers call me about is sometimes they're not certain. And frankly, lawyers that call me about different deals, they actually have the right ideas, but they want some additional level of certainty. So even lawyers are not certain about everything, even if they've done their research and so on. And basically, I just ask questions: where have you looked? What have you tried? Things like that. And I can sometimes confirm stuff. The thing that I help people with sometimes that are in the legal field is they'll ask this open-ended question: are there any other possible things I should think about with this type of case? And of course, I can't necessarily give them an answer from the law, but just based on experience, I may think of something additional that others may not have thought of. Okay. Yeah. I mean, but a lot of times it isn't like damages necessarily, but it may be something else related to the topic in law, some solution to something that I have tried or I didn't try, but I thought of in the past. Some personal injury matters. For instance, there may be some items that just don't apply because there's no permanent injuries. Yeah, you can identify those. Yes, absolutely. Yeah, but define things from a source. Don't just define things. And I don't want to be harsh and mean and say nobody cares what your thinking is. They care what your thinking is, but they don't care for your final word on the definition. Okay? Use the text or other source for each definition. So if you said hedonic damages, a lawyer would want to know where'd you get that? And even if the lawyer knows where you got it, it's nice to have it in print because then in the list that they use for negotiation, they've got it right in front of them. Things get hot and heated and competitive and nerve-wracking sometimes. It's nice to have a set of key citations right in front of you. Yep. But each one has a cite, Corey. So if we wanted to do this, we might insert a table. We could do a 4-column table. Well, 3, I suppose. I did a 3-1, but maybe this is too small print, isn't it? Okay, you got hedonic damages, and you got application, site for death, definition, bills. And again, application to case. Any questions about that? Questions, problems? I love tables because they force you to think. And then a lawyer can skip through and say, I think that's bunk for this case, but they can easily see the categories. And so you've got, let's say you've got a bunch of categories. The lawyer can skim through and say, oh, okay, I got the citations right here. No, I got them. I can analyze whether I agree with the paralegal on how it applies to the case, right? And I have, like I say, I've tasked a couple lawyers, how would you like a table instead of a different format? You know, you can certainly do that. It's got to show your logic. That's the key. If it prompts you to use logic and it prompts you to use sources, it works. So you got types of damages. You got your logic, which is what do you think? And over here we've got what did you find and where did you find it? Right? Here's what I found. Here's where I found it. Here's what I think. And here's the obvious categories. Yeah, you do not have to use table format. Table format is sort of my way of trying to get folks to be, to make their thinking clear. I would like lawyers that you work for to be able to skim through and say, here's what the person found. I can get right to if I want to, but I want to see what my employee thinks, and I know where to look. It's easy. Easy, easy, easy. I want it to be so darn easy for them to find what you think and find out where you looked. Where did you look to find your sources? What did you figure out? They can find any of that stuff really easy. And I've certainly seen some good memorandum formats that work for them very well. You know, you can certainly use a memorandum format, but use some format that makes it easy to see the source for each answer and the thinking for each answer. If the lawyer cannot see the source for your answer or the thinking for your answer, or it's mixed and muddled, it's not as useful in my opinion. your own personal thinking, so you're either uncertain, or you're pretty sure it works, or you're pretty sure it doesn't work for your case, your fictional case. Uncertainty is good because in the law office it helps you ask for more facts. You might ask it from your own client, or you might ask for more facts from the other side. Where facts are weak or non-existent, ask for documents. Don't ask if there are documents, ask for the documents, okay? Now, if somebody asks me, please send all documents for the hospitalizations you have had for the last 3 years. No, I haven't had any hospitalization for the last 3 years. But that's still not an impolite or illegal request. My answer is just none. I have not supplied any because I've not had hospitalizations for the last 3 years. Does that make sense to you? You see where I'm coming from? You don't have to ask me a preliminary question. If I was in a case, you can ask for a list of my hospitalizations for the last 3 years. You don't have to ask if I had any first. You know, and you can ask for my medical records for the last 3 years on all hospitalizations for knee injuries. Yeah. So ask the other side. Just an example. All records from. Now, we're not asking them questions right now. So records from hospitalizations for knee injuries. But a lot of people seem like they're putting their own personality into this. Don't use your own personality in a records request. If you're an extremely sweet, polite person, don't be that way for this document request, okay? It's not like you're coming up to somebody and shaking them and asking them to dump out their purse, okay? Or their billfold. Yeah, cut to the chase. Yeah. Yeah. You don't have to, you may say please, that's okay, because that's just a format thing. Okay. You could say we demand, or please. Either one works. Local practice. Yeah, it's frankly, if you're asking for somebody's personal private medical records, they won't like the lawyer you work for anyway. But if it's relevant to the case, you know, pre-existing injuries, they won't like anybody that works in your office because you're all stinkers, but you were perfectly correct in asking for it. So whether you say please or you use the word demand, either way is fine. You'll still get them, okay? You know. But lawsuits don't make people like you. If you represent the other side and you ask for things that they think are unfair requests, well, the knee injury that I had when I was playing basketball has nothing to do with the knee injury that I had when I was in the auto accident, and they were rude to ask for it. Well, maybe they said please or whatever, but you know where I'm coming from? Yeah. But from the point of view of anybody in a lawsuit, everything the other side does is rude and mean. Of course, insurance companies are obviously a little more objective and don't take things as personally, but the actual defendant will take things personally. The actual plaintiff will take things personally. If the plaintiff has asked for their income proof, they don't like that, but their lawyer will advise them that they have to provide it. Well, I should have been the manager for the last 3 years, but if people there had a head on straight, I would have been making, 6 figures. But can you put that in? Well, no, we'll just have to provide your pay stubs and your tax returns. And that person will not like it. Although, like I say, maybe I'm exaggerating a little bit. Clients do try to understand why we're doing what we're doing, but I've had clients that were asked for things like their level of education, and they objected strenuously. But if it was at all relevant to the case, then we had to provide it. Okay. Yeah. We do want to be polite, and like I say, lots of places do use the word please, but they don't mean it in the sense of if you choose to be nice, you can provide these items. If you're asked please in a records request, that means you have no choice. You have to provide it. Unless it's truly objectionable. They ask for somebody with a knee injury, the psychiatric history that the person has of taking a medication for psychiatric illness has nothing to do with their knee injury, so they can object to it. Okay? Yeah. Mary Bowman, plaintiff, and so on. Discussion, Martha Peterson. Just check to see if any of the cans have been violated. And the Module 5 classroom magic words are just general damages. Did I give you a different one before? I hope not. Yeah. Yeah, and Angie put some good examples into the chat about clients wanting to give us a release for only one doctor, but they want all of the records. Yeah, rather than just a selected set of records, because they are, in order to do the job, they need all the records. And we will talk about Module 6 next week. So this is all I had. Do the best you can. I will be gone this weekend, but I will check in once in a while and check my course messages and some other stuff, okay?